Ready? Exercise number 13 and 14 legal matter start. The faulty repair to the transformer resulted in a loose connection that led to the catching of fire to the transformer, and all the cars in the parking lot were burnt in the fire, which resulted in suffocation for viewers of the cinema in the hall. Further, it was held that in that case there was an addition of an 8-seater box that closed off the exit on the right side of the balcony. It was also found that the owners of the cinema have added 52 additional seats to the theater, which blocked the gangway on the right side of the movie hall. In the aforesaid case, both A1 and A2 were found guilty not by virtue of their position in the company but rather by virtue of specific allegations made against them. In the aforesaid case, accused themselves were found to be occupiers. There were gross statutory violations which had a direct nexus with the death of the victims. Further, looking at the facts and circumstances of the present case, the said case cannot be applied against the appellants accused. Having regard to the case law referred above, by applying the facts of the case on the hand, we are of the view that the case of the appellant accused number 2, Shiv Kumar Jatia, in criminal appeal at the rate SLP under bracket criminal bracket out number 8008 of 2018 falls within one of the categories enumerated in the case of State of Haryana versus Bhajan Lal to invoke the inherent powers under section 482 of CRPC, either to prevent the abuse of the process of court or otherwise to secure the ends of justice. In the criminal appeals at the rate SLP under bracket criminal bracket out numbers 10054 10056 of 2018. The sister of the victim has also questioned the directions issued by the High Court allowing them to appear before the trial court through an advocate and by permitting them to appear as and when there is a specific direction by the trial court to appear before such court. It is the case of the appellant complainant in the above said criminal appeals that while dismissing the criminal miscellaneous cases filed under section 482 of CRPC, the High Court has committed error in issuing directions as referred above. It is the case of the said appellant that to dispense with personal appearance and allowing the accused through an advocate can be considered only by the magistrate under section 205 and slash or 317 of CRPC, but without recording any reason the High Court has issued such directions which are impugned in the appeals. Stop. Next exercise. Leave granted. This civil appeal is filed by the first defendant slash National Aluminium Company Limited under bracket NALCO bracket out, a Government of India enterprise in pending civil suit number 2610 of 2015 on the file of learned senior civil judge Gurgaon, Haryana, aggrieved by the order dated 22/10/2016, passed in Civil Revision number 2471 of 2016 under bracket O and M bracket out by the High Court of Punjab and Haryana at Chandigarh. The Appellant Company, a Government of India enterprise, has issued a tender notice on 5/5/2011 inviting tenders for construction of Ash Pond 4th in district Angul of Odisha state. The first respondent herein, that is Subhash Infra Engineers Private Limited under bracket for short SIE bracket out, has submitted its offer/tender on 6/6/2011. On 9/11/2011, the appellant herein has accepted the offer/tender submitted by the first respondent herein and issued the work order to the said respondent by a letter dated 18/11/2011. The appellant addressed the first respondent to attend a kick-off meeting on 19/11/2011. As no one on behalf of first respondent attended the meeting proposed on 19/11/2011, the appellant again issued a letter dated 21/11/2011 requesting the first respondent once again to come for a kick-off meeting. In response to the letter dated 21/11/2011, the first respondent/SIE herein by the letter dated 21/11/2011 expressed his inability to execute the work unless certain specifications are changed/revised. In the said letter dated 21/11/2011, the first respondent/SIE herein has agreed that the appellant company has accepted the offer made by it. Further, by the letter dated 2/12/2011, the respondent/SIE informed the appellant that the work order is not acceptable to them. Subsequently, when the first respondent herein was not coming forward to participate in the kick-off meeting and instead addressed a letter dated 2/12/2011 while the letter dated 30/1/2012. The appellant company informed the respondent/SIE that the contract works will be carried out through some other agency. At the risk and cost of the respondent/SIE, further by letter dated 6/2015, the appellant company has informed the first respondent/SIE that it suffered a financial loss of rupees 4,86,61,440 under bracket rupees 4,86,61,441 bracket out. The respondent/SIE was directed to deposit the said amount, otherwise the appellant will be forced to invoke arbitration clause as per clause 22 of NIT and clause 87 of the general conditions of contract. Then the first respondent/SIE has disputed the claim made by the appellant on the ground that there is no binding contract that came into existence between the parties. As such, the demand is illegal and unjustified. Stop. Thank you very much.